Ms. Tang Wei Neng.
Deputy Speaker, sir, the proposed changes to the Criminal Law Reform Bill are timely and relevant. In general, these amendments reflect the sentiments on the ground. The amendments have broadly enhanced protections for the vulnerable in the society and tackles emerging crime trends. I'm glad our legal justice system is sufficiently nimble to move with times, and I stand in support for the bill. However, there are a few sections which I have some concerns with. According to the World Health Organization, WHO, Singapore ranks 62 out of 176 countries with suicide rate of almost 10 suicides per 100,000 people. This also means that Singapore has 2.5 times death from suicide as compared to the transport accidents in 2017, when 361 people killed themselves. In terms of trends, men accounted for over 66% of these deaths, and the number of elderly aged above 60 who took their life also reached an all-time high in 2017 at 129 suicides. This is the highest since suicide tracking started in 1991. With the current bill, Section 309 of the Penal Code is repealed. This means that attempted suicide is no more a crime. We finally recognize that it is more important to rehabilitate and support those who want to commit suicide, rather than arresting and prosecuting those who have attempted suicide. As a police officer in my younger days, I have attended to suicide cases as well as attempted suicide cases. In one very memorable instance, I had to visit a young lady in a hospital after her second failed attempt at suicide. I had to record her statement and warn her that it was an offense to attempt suicide. She was indifferent. She did not care less of what I say. A few days later, she made a third and final attempt, which was successful. For people who are determined to end their life, arrest and threat to charge them in court is a poor deterrent of reoffending. With that in mind, I would like to ask the ministers how many cases of attempted suicide were reported from 2010 to 2018, and of those, how many persons were arrested, and how many persons were arrested repeatedly. Under the current law, the abetment of suicide is a crime. I would like to ask the ministers how many cases of abetment of attempted suicide or suicide were reported between 2010 and 2018. The above statistics are important. The statistics are important for us to understand the underlying trends of suicide rate in Singapore and the effectiveness of our suicide prevention program. With the decriminalization of attempted suicide, I hope that government agency will not trivialize the act of attempted suicide, especially if the police is no longer involved or is playing a minor role. I hope more resources, not less, will be channeled to help those who attempted suicide. More resources in terms of counseling to help the victim and the victim's families. More resources in terms of in-depth study on the causes of attempted suicide and suicide. It's through this approach that we can better preserve the sanctity of life. Perhaps we could look at what Koreans have done. Korea has one of the highest suicide rates in the world and the highest among the OECD countries. What the South Korean government did was to conduct an extensive study of 70,000 people who committed suicide from 2012 to 2016 to establish a national surveillance system on suicide trend, to analyze patterns and statistics on the causes of suicide and who is more likely to attempt suicide. We build strong local networks by educating medical and social workers on the ground so they can immediately respond to those thinking of taking their own life. It also strengthened depression tests to identify those who might be at risk. We can take a lead from the Korean experience. At the minimum, I suggest that we should mandate those who attempted suicide to go for counseling or treatment. For this to work, our anti-suicide efforts need to be an inter-ministry collaboration involving the police, MSF, and other stakeholders. Another area we have to be concerned with is teenage suicide. This is particularly problematic because the views are shockingly vulnerable. Suicide is the leading cause of death for those aged between 10 to 29 in Singapore. These youth and teens are increasingly at risk of self-harm due to bad influences through social media and challenges. Such dark challenges could disguise as Momo Challenge, Blue Wheel Challenge, and hashtag KYS, that's kill yourself. When the youth feels stressed and distressed, they can easily go online to search for methods on how to kill themselves. Thus, I hope that even with the decriminalization of attempted suicide, police should not wash their hands completely. Whenever there's such a self-harm reported, the police should still be alerted to rule out any abetment of suicide. The police can still be the referral agent to mandate Singaporeans who have attempted suicide to seek help. Next, on Section 323, voluntary causing hurt. The new Section 323A fills a gap between hurt and causing grievous hurt with intention. The bill also enhances the punishment when hurt is inflicted on domestic workers, vulnerable persons, and persons less than 14 years old. This is timely, appropriate, and necessary. However, there's still a gulf between how the police handle voluntary causing hurt cases and that of the voluntary causing grievous hurt. Voluntary causing hurt under Section 323 is a non-seizable offence. There are many injuries which do not fall under grievous hurt. Grievous hurt relates to very serious injuries such as fractures, blindness, or other permanent disability. Very often, hurt can also be serious, resulting in profuse bleeding, hospitalizations, or a few days of medical leave. Yet, it is still not serious enough to be classified as grievous hurt. An offence is not seizable. The problem of non-seizable offence is that the police cannot make any arrest without a warrant. The victim of voluntary causing hurt has to lodge a magistrate complaint with the court. This is an onerous administrative process costing $20 and requires the victim to lodge a complaint personally at the court. He also has to buy a medical report from hospitals or clinic to state how he has been hurt. This whole process is obviously a deterrent. So, only then, when the victim of the voluntary causing hurt make a magistrate complaint, then the police will be directed by the magistrate to investigate. Hence, many perpetrators, many persons who try to hurt other people, get away with it quite easily. And in UK, you can get arrested for committing such offences. Common assault, which including pushing, slapping, or merely spitting at people. Such offences carry a maximum penalty of 6 months in prison. Actual bodily harm, which is a step up, constitutes actual physical harm, which does not need to be serious. Actual bodily harm include bruises, scratches, and bite marks. An offence carries a maximum sentence of 5 years in prison. I would like to ask the Minister, how many cases of Section 323 were reported in 2018, and how many cases were investigated by police due to magistrate complaint, or how many cases were initiated by the police to investigate without a complaint to the magistrate, and how many cases were eventually prosecuted in court. One extreme is to follow the UK's examples of making voluntary causing hurt a seizable offence. I do not think the police is ready for this, and I would like to propose somewhere in between. I would like to propose that the Minister consider requesting the police to initiate investigation for all cases of voluntary causing hurt that fall under the following categories. A. Road bully. There is assault arising from dispute of a car accident or the near-miss car accident. B. Assault by the customer on the customer service staff. Assault by a customer on customer service staff, be it a waiter, a waitress, a salesperson in a department store, a customer services officer at the counter of the telco or cabbies. Assault resulting in victim suffering an injury that needs more than 1 day of medical leave to recuperate. In the first place, there's no good reason for a person to assault another without provocation. Worse still, a customer service staff should not be assaulted by the very customer he or she is trying to serve. If the police can initiate investigation for such assault cases without the need for the victim to lodge a magistrate complaint, it will go a long way to deter such violent act and bring justice to the victims in a fast, decisive, and appropriate manner. At this juncture, I would like to declare my interest as the CEO of ComfortDelGro Taxi Business before I continue my speech in Mandarin. 副会长先生，单单在2018年的时候，就有40起康复德高的德士师傅 被达克殴打。然而，案件属于蓄意导致他人受伤，而非蓄意导致他人受重伤，所以警方不一定介入调查，除非受害者花钱花时间往推事庭提出投诉，要不然他们都不会得到帮助。所以结果，40起德士师傅被达克殴打的事件的当中，最终将肇事者控上法庭的只有4起，40起德士师傅被殴打，只有4起，警察把他们控上法庭。所以多数的受害者只能眼睁睁地看野蛮的达克逃之夭夭。目前，蓄意导致他人受伤和蓄意导致他人受重伤的分别非常大。重伤的定义是骨折、眼瞎等严重的伤害，就像是被人打到头破血流，住院留几天，也不一定算是重伤，所以警方不一定会主动调查。受害者要申冤的话，就要得花钱买医药报告，证明被打伤，还要拿假期在办公时间内花20块钱向推事庭提出投诉，警方才可以出面调查。耗时耗钱，看起来对受害者似乎有欠公平。所以我建议这位部长考虑要求警方在某种情况之下，就算不是重伤，也主动调查蓄意导致他人受伤的案件。比如受害者伤势需要超过1天的病假康复，或顾客对服务人员动粗的情况之下，警方可以马上介入调查，甚至将动粗者控上法庭。Deputy Speaker, sir, I would like to continue my speech in English. It's good that we are finally repealing the marital immunity for rape, following the practice of other countries such as UK, US, and Australia. We want to protect all women from sexual abuse, especially within the confines of the marriage, where they are most vulnerable and may find it difficult to say no. The amendment empowers them to step forward because the law has been broken. However, we do have to be careful to guard against false allegations of rape in instances where a married couple is not yet divorced, but the marriage has already broken down, and the woman may want to move to fulfill a personal agenda. Either that, or it could be a difference in interpretations using another context. There have been cases of women who claimed that she was raped, but men said it was consensual sex. Such charges are inherently based on he say, she says, whereby it's quite impossible to obtain good evidence. It is challenging to prove a lack of consent in marital rape due to the intimacy associated with marriage and the fluid nature of consent. Some even ask if a husband is supposed to get consent from the wife every time they have a sexual relationship. A wife who has consented may later retract it in the heat of subsequent arguments. While it's morally right to protect women from abusive husbands who force themselves on their wife, I would like to ask the Minister what additional safeguards besides enhancing the punishment or providing false statement, if any, the police will take to prevent and deter such false allegations. Will no signs of a physical injury be sufficient to prove a false allegation of marital rape? I hope the ministers can provide us with more insight. Mr. Speaker, sir, Deputy Speaker, sir, in conclusion, the Criminal Law Review Bill is timely. I would like to thank the Ministry of Home Affairs and those who are involved in the Penal Code Review Committee and the public for the valuable contributions in making sweeping changes to update our penal code. Thank you.